Dave, you said like 60 something people register?
Yeah. Yeah.
Okay. We'll give everyone a couple more minutes then.
Yeah. Okay, welcome everyone. We are just going to wait a few minutes to give everyone enough time to log in. But as you can see in the chat, if you could, in the meantime, just put your name and organization, your full name and organization in the chat so we can record that for CLE purposes, that would be great.
And also a gentle reminder that we will be recording this for CLE purposes as well. So if you don't want to make an appearance, turn your camera off and kindly mute yourself.
So hi everyone, for those who are just joining us, we're just waiting just a few more minutes for people to log on. In the meantime, if you could just please in the chat, put your full name and organization so we can record that for CLE purposes. Okay, let's get started. So welcome everyone to the Access to Justice training today. Today's training is going to be on assault, battery, and domestic violence offenses, specifically their impact on removability and relief. We will be recording this training, so feel free to turn your video off if you don't want that to be part of the recording. My name is Dave Faherty, and I am a supervising attorney on the detention project at NIJC, the National Immigrant Justice Center. And I'm co-presenting today with my colleague, Lupe Perez.
Good afternoon, everyone. Just general housekeeping items. I think most of you caught this from Dave's spiel. And remember to put your name and organization in the chat box for CLE purposes. And we will be giving out CLE codes throughout the presentation. So I have that pen handy.
Great. Okay, so let's get started. So our agenda today, we're going to start with a brief overview of the categorical approach, which of course is important whenever we analyze criminal offenses and their effect on removability. We'll also do a brief overview of the crime involving moral turpitude, aggravated felony, and domestic violence removal grounds and their impact on relief eligibility. Then we'll go into applicable standards and hypothetical examples with specific Illinois statutes and case law for these grounds of removability. And specifically, we're going to focus on Illinois battery offenses, assault offenses, domestic battery, and order of protection violations. And then we'll have time at the end for questions and answers. Also, feel free to, as we're going through this, feel free to chat us questions. We'll try to monitor those, and if we don't get to them, we'll try to get them at the end, but we will try to respond to them as they come in. So let's start with the categorical approach. So this is the methodology in which adjudicators look at whether criminal convictions carry immigration consequences. And the key here is that the facts of what actually happened are not important. It's really the elements of the offense, the elements of the statutory offense. And so, like, specifically in the immigration context, it applies when determining whether an offense will trigger an inadmissibility or deportability ground. And so the adjudicator, like the immigration judge, is really just going to look at that statute of conviction and not what actually happened. The important thing to remember is, and to know, is whether in each situation the categorical approach actually applies. It applies in most grounds of removability, but not in every situation. And so when we're engaging in the categorical approach, in a categorical inquiry, we look to see if the elements of a state statute actually match their federal or generic counterpart. And so, just as an example, if a state offense punishes conduct that is not punished under a federal definition, then that's when we would call that state offense to be overbroad. And these are just sort of two examples, sort of like visual examples of that, in which a state offense has more conduct that it criminalizes than its federal counterpart. And so here are some basic steps in the categorical approach in that analysis. So step one, we need to figure out, like, what is the actual statute and definition that we are looking at. So first step is, what statute was your client actually convicted under? And then you want to look at the generic or federal definition of the removability ground to figure out what the definition of that is. And sometimes, sometimes that's clear from the face of the INA. Sometimes you have to do more research into what the courts have defined that to actually mean. And then, that goes to the next step here, is what are the elements of each offense? Then step two, do these elements, do the state and the federal elements, do they match? If yes, if it's a clean match, then your client is probably going to be removable on that ground. But if it's a no, if there's some sort of overbreadth between the state conviction and the federal conviction, then that statute would be overbroad. And then step 3 it's part of the categorical analysis. We won't spend too much time on this, but it's called the realistic probability test. The basic idea is that even if there's an overbreadth between the state conviction and the federal standard, we need to show that there's a realistic probability that the state would actually punish that overbroad conduct. There's sort of actually a circuit split on this right now on whether when the face of the statute is clearly overbroad, whether you still need to show this realistic probability of prosecution. And the way you typically do that is you say, well, look, here are examples from case law of the state of Illinois, for example, actually prosecuting this kind of conduct. Or you could even say, like, my client was prosecuted for this overbroad conduct. But there's sort of like an issue there in whether if the statute is overbroad on the face of the statute, whether that's sufficient for the realistic probability test. But we won't really get into that, but that's sort of a developing area right now. And so the next step in this categorical analysis, if you have an overbroad statute, the next question is that statute divisible? Meaning, is it divisible into different crimes in which some crime would not be overbroad and some crimes would be overbroad? And so if the answer to that divisibility question is yes, then you have to, figure out then, like, if there is a categorical match to that divisible crime, and if your client's crime actually is that divisible crime that matches the generic offense. And so if that's the case, you go to the next step to review the record of conviction to actually determine which divisible crime your client was actually convicted under. So there are many steps to this process, but it's important to sort of start from the beginning and then go down. And then, under Mathis, which is sort of the key case right now from the Supreme Court on the categorical approach and divisibility, there are like other steps that you can look at for the divisibility analysis specifically. So to determine whether your statute is divisible, the first step is to look at the statutory text to see if the state statute has sort of clues as to divisibility. And one of the key clues in the statute's text is whether there are separate penalties for different types of conduct. Like, for example, if there are like 4 subsections and each subsection has a different penalty, that's probably going to indicate that that's a divisible statute, and the different subsections are essential elements or like separate crimes, basically. Another place to look is to look at state case law, where a state's highest court will somehow definitively answer this question of whether the statute is divisible. And just a tip when you're looking for this, look for these state appellate cases addressing the sufficiency of the evidence, and also double jeopardy challenges will sometimes go into these issues. Another place to determine whether a statute is divisible is other state case law and pattern jury instructions. And then finally, there's sort of like a last place where you can look, and it's called a peek at the record of conviction. And the idea is that you look at the record of conviction for the sole purpose of determining whether it's clear whether this statute is divisible. And then when you actually apply the modified categorical approach to a statute that is divisible, what that means is, instead of just being confined to the language of the statute under the categorical approach, you then can look at a wider swath of documents in the record of conviction. And those include the charging document, the plea agreement, a transcript of a plea colloquy, judgment and sentencing documents. And you can look at those documents just for the purpose of determining what subsection or what part of the statute was the client actually convicted of. But just want to note that police reports are not a part of this modified categorical inquiry. So police reports will typically be submitted by DHS in the cases that we have, but you cannot look at them for this purpose. And so also just want to mention, we're going to talk about CIMTs today, but within the categorical approach, there's been sort of a history with CIMTs. And it started where we've kind of gone back and forth on whether we actually apply the categorical approach to CIMT cases. And it started in 2008 with Attorney General Mukasey with the first Matter of Silva Trevino case, in which he said that actually we're not going to apply the categorical approach whenever we have a CIMT issue. We're just going to allow a factual inquiry into what actually happened in each case. And so after that, as we know, decisions of the Attorney General and the BIA are reviewable by the circuit courts. And over the course of about 7 years, 5 circuit courts took up that issue and refused to adopt that line of reasoning, saying, no, really, we cannot do this factual inquiry. CIMT cases are just like any other ground of removability, and we have to look at the statute of conviction and perform the categorical approach. And then in 2015, a new Attorney General, Eric Holder, vacated that first Silva Trevino decision in what's called Silva Trevino 2, and vacated the decision and sent it back to the BIA to do it again, with a nod to the categorical approach. And that's what the BIA did in 2016, in which it issued Silva Trevino, the third version of that, which reestablished that we do apply the categorical approach for CIMT cases. And so when we talk about removability, just briefly to go over this, we're actually talking about 2 different provisions of the INA. Under section 212, we have grounds of inadmissibility, which apply to individuals who have not been admitted to the United States. And then we also have a separate ground called the ground of deportability, which is under section 237 of the INA, which applies to individuals who have been admitted to the United States and who now may be deportable for a certain reason. And so these grounds, there's a lot of overlap between grounds of inadmissibility and deportability, but there's also there are a lot of differences between them as well. And so we'll get into that a little bit briefly. Just for example now, so criminal grounds of inadmissibility under section A2 of 212, we have the crime involving moral turpitude, in which an admission even of this sort of offense would be sufficient. There is a petty offense exception for misdemeanors in which the sentence is under 180 days, but that's only for 1 CIMT conviction. And then there's a list of other offenses which would trigger this inadmissibility ground of 212. And then for criminal grounds of deportability under 237, a conviction is required for all of these offenses. And CIMTs is a ground of deportability as well, but it's a little bit different. You could have 1 CIMT offense that's committed within 5 years of admission, if it's a felony CIMT offense, or you could have multiple CIMTs committed at any time. And then the other big difference here, which we'll talk about today, is aggravated felonies. These are certain offenses that are defined under the INA, which only factor as a ground of deportability. They're technically not a ground of inadmissibility. And also domestic violence and protection order violations also fall under 237 as a criminal ground of deportability. I'm going to switch now over to Lupe.
Excuse us while we do our tech. All right. So let's take a closer look at CIMTs. And this is going to highlight the differences that Dave alluded to of CIMTs between the ground of inadmissibility and the ground of deportability. So the first key difference, as Dave mentioned, was that for CIMTs under 212, a conviction is not necessary and admission is sufficient. But just be careful, because in order for that admission to be sufficient, the client would be needed to be advised of the statute and also have to admit to the elements in order for that of the crime in order for the admission to be sufficient. For 237, of course, you need a conviction. With regards to misdemeanors or to misdemeanor CIMTs, a misdemeanor CIMTs would make someone inadmissible unless it falls under the petty offense exception, which we will talk about. Generally, for 237, a misdemeanor CIMT would not make someone deportable. However, beware of that misdemeanor label, because some states do have sentences of 365 days and still classify them as misdemeanors. With regards to felony CIMTs, any felony CIMT would make someone inadmissible regardless of when it occurred or the sentence. However, in order for a felony CIMT to make someone deportable, it would have to occur within 5 years of admission. And then multiple CIMTs track both with 212 grounds of inadmissibility and 237 grounds of deportability. Multiple CIMTs would make someone inadmissible and would make someone deportable. So a little bit more about the petty offense exception. That's defined under INA 212 with the grounds of inadmissibility. And that just says that a single misdemeanor CIMT and someone who was sentenced to 6 months or less of jail time, that falls under the petty offense exception. So that particular conviction would not make someone inadmissible. So CIMTs, I think the Seventh Circuit has some pretty colorful language about what their thoughts are regarding CIMTs, because they can be pretty nebulous in nature. So think of them generally as falling into one of two types. They can involve deceit and or stealing. And for those of you who were in our presentation last month, we talked a little bit about fraud, forgery, and lying to law enforcement. Today, we're going to be covering a little bit more about the second type of CIMTs, which involve intentionally, knowingly, or sometimes recklessly causing bodily harm. Sneak peek into the rest of the presentation, take a look at the mens rea that normally CIMT requires. Some of the examples that involve this second type of CIMT include domestic battery, aggravated assault, and battery offenses, which we will go into a little bit more in depth in the rest of the presentation. Then, as Dave mentioned, domestic violence itself is a ground of deportability found under INA 237, A2, capital E, little I. This is the full statutory language of domestic violence, and we will break it down in the rest of the presentation to really look at what elements must be met in order for a conviction to fall under domestic violence. So generally, domestic violence have to be a crime of violence as defined by the United States Code, and the victim has to be a protected person under the United States Code. We're going to look a little bit more at what does it mean, or what is the definition of a crime of violence in a little bit. So looking at domestic violence offenses, they can get a little bit tricky because having a conviction for a domestic violence offense can be used in 3 different ways under the INA. So sometimes domestic violent offenses can be CIMTs, sometimes they can be crimes of domestic violence, and sometimes they can be aggravated felonies. Sometimes they're all 3, sometimes they're just 2, sometimes they're just 1, but you have to look at the definition of each category in order to determine if the statute that your client was convicted under falls under one of those 3 buckets, let's call them. So when looking at when your client has a conviction for domestic violence, you have to look at the statute and see if in order for it to be a CIMT, it involves knowing or perhaps recklessly causing bodily harm. And we're going to go over some examples to look at that point more. And then in order for domestic violence convictions to be crimes of domestic violence under the INA, they have to involve the use or threatened use of violent force against a domestic partner. Keep in mind that it doesn't necessarily have to follow the categorical approach. It could also use the circumstance-specific approach in order to determine the domestic nature of the offense. And then for crimes in order for a domestic violence conviction to be an aggravated felony, so as Dave mentioned, there are many aggravated felonies, but the one that we're going to be specifically looking at today is the crime of violence aggravated felony. And we'll go over the definition of it a little bit, but it has to involve the use or threatened use of violence force and the 1-year jail sentence. So if you have a client coming in who happens to have a domestic violence conviction, you have to analyze it under the 3 different buckets of grounds of deportability in order to determine in what way, if any, it could be used against that client. We're also going to be talking a little bit about orders of protection. And that's also a ground of deportability found under INA 237. And it's not the issuance of an order of protection that will make someone deportable. It is the violation of that order of protection. And it has to be the violation of the portion of the order of protection that involves protection against credible threats of violence, repeated harassment, or bodily injury. And the BIA in matter of stridum held that the violation of no contact provisions falls under violations of orders of protection because the purpose of having those no contact provisions is to prevent those future threats of violence, harassment, or injury. Similarly to the domestic violence ground of removability, the Seventh Circuit has held that you don't need you don't apply the categorical approach to order of protections violation. So you can look at a person's record to determine what portion of an order of protection was violated. So now that we've gone over several grounds of removability, we're going to talk about how they interplay with the effect of someone's relief eligibility. So aggravated felony bars, as Dave mentioned, aggravated felonies are only listed under 237. However, they have the harshest consequences. Flagging at the outset that if an undocumented person is convicted of an aggravated felony, they can be removed via final administrative removal order. So they won't have the right to see an immigration judge and will be barred from most forms of relief. Aggravated felonies are per se particularly serious crimes for asylum. And next month, we will actually be doing a presentation on criminal bars to protection-based claims. But aggravated felonies are also bars to LPR cancellation and non-LPR cancellation. They are a bar to voluntary departure and to the 212H waiver if someone entered as an LPR. With regards to custody, being convicted of an aggravated felony will make someone subject to mandatory custody, so they will not be eligible to receive a bond from an immigration judge. So see, for crimes involving moral turpitude, unless it's subject to a petty offense exception, CIMTs will bar people from non-LPR cancellation, and then good moral character within the requisite period of relief that you're seeking, post-conclusion voluntary departure. And then CIMTs will make someone inadmissible looking at the grounds of 212 unless they're eligible for a waiver, or of course, unless they fall under the petty offense exception. And then with regards to bond, if someone entered without inspection, unless they are subject to the petty offense exception, those convictions, they will make someone ineligible for bond. And then keep in mind that CIMTs do not bar folks from asylum. However, they could be independently classified as particularly serious crimes, which would bar folks from asylum. And again, we'll probably cover that in next month's presentation. So getting into assault and battery convictions more specifically. So assault and battery, normally you need a higher mens rea in order for something to be classified as a CIMT. However, the requisite mens rea goes down as the level of injury required goes up, or as more aggravating factors are present in the statute, or as the BIA has deemed that there's more of a protected relationship or vulnerable victim within the statute itself. Keep in mind that simple battery is not a CIMT, and we're going to go over into some hypotheticals about when domestic batteries are CIMTs, and also when aggravated batteries can be CIMTs. So Matters Sanudo has really good language as to what factors and what things you can look into to determine if an offense is a CIMT or not. Keep in mind that CIMTs are generally those that are inherently base or vile or depraved and contrary to the accepted rules of morality and duties owed between persons or to society in general. That's a pretty broad definition, but keeping that as your general baseline, that's why not all crimes involving injuries touching of another reflect moral depravity. So just because the statute has injuries touching, that may not be found to be a violation of that duty that we owe each other in society. However, keeping in mind that some aggravating factors can significantly increase culpability. So if there's a presence of an aggravating factor that is seen as a violation of that duty that we owe to each other, then that could also increase the likelihood that something will be found to be a CIMT. And this BIA has found historically that the intentional infliction of serious bodily injury is a CIMT. Note both the mens rea required intentional and the level of bodily injury that was in that statute in order for it to be found a CIMT. And then the last factor that case talked about was, what is the status of the person on whom that harm was inflicted? Did we as a society deem that that person needed a special protection or a higher level of protection than others? So in order for battery and assault offenses to be found to be aggravated felonies, we have to look at crime of violence definitions under the INA, and that's under 101 A43F. And that definition, of course, refers to another section in the United States Code, because if not, it would not be a federal statute, as they traditionally like to refer to multiple subsections. But a crime of violence is defined elsewhere, and we'll look at that definition in a little bit. But the second element in order for something to be found to be a crime of violence as an aggravated felony is the term of imprisonment must be at least 1 year. So someone has to be sentenced to at least 1 year of imprisonment and have the definition and have the statute fall under definition of a crime of violence in order for it to be a crime of violence aggravated felony. Note that suspended sentences count under that 1 year imprisonment. So what is a crime of violence? So under the United States Code, there are two subsections. However, the second subsection, 18 USC 16B, has been stricken down because that particular subsection talked about offenses involving a substantial risk of physical force. The Supreme Court held that substantial risk was unconstitutionally vague, so something will not be found to be an aggravated felony as a crime of violence under subsection B. However, subsection A still has the definition for what a crime of violence is. And it's an offense that has an element, the use, attempted use, or threatened use of physical force against the person or property of another. So in order for something to be found to be an aggravated, in order for battery or assault offenses to be found as aggravated felonies for crimes of violence, they have to have that definition, and they also have to have that sentence. So let's look at some hypotheticals. So this is the Illinois battery under 720 ILCS 5-12-3. Take a moment to read the statutory language. And we've also given you the sentence here. Is this a CIMT? Is this an aggravated felony? And is this a crime of domestic violence? Looking at that statute, what would it fall under, if anything? And I believe we have a poll, so let's see if we can do this with our tech. Let me see if I can launch the poll. Yes. All right. So I'm going to launch the poll, and you should still have access to the statutory language in order to cast your votes. Okay, I think we have, oh, I'll give it a couple more seconds in order for you guys to finish participating. It's anonymous, so no one will know what your answer was. Okay, so I think we've had most people. We're just waiting for a couple more. Okay. I didn't see any more answers coming in, so I'm going to end the polling. Don't worry, y'all. We have a lot of polls for the rest of the presentation. So if you didn't get your answer in on time, there will be plenty of opportunities. So I'm going to share the results just so that people see where we are at. So looks like a good majority of you said that it was a CIMT. Some people thought it was a crime of domestic violence. Some folks said that it was an aggravated felony. Others said that it was none. And some folks said that it depends on the subsection. So yeah, yes, this was a bit of a trick question. So it does depend on the subsection. So you have to, this battery statute is divisible. So subsection A1 is a CIMT, and it could be a domestic violence. So it's a CIMT because look at the, let's see if I can go back. Look at the level of injury that it causes. It causes bodily harm. It could be a crime of domestic violence if we have documentation that the victim was under that protected category of falling under partner. Neither of the subsections will ever be an aggravated felony because look at the sentence. It is a class A misdemeanor. So there will be no way that someone will be convicted and sentenced to a 365-day sentence. Subsection A2, the one that involves offensive touching, is neither a CIMT, a crime of domestic violence, or an aggravated felony. And the reason for that is that it doesn't have that level of bodily harm. It can make physical contact of an insulting or provoking nature, which is overbroad in nature. But it's still a negative discretionary factor, especially for those forms of relief where you need to, that are discretionary in nature. So let's take a look at the second general overview of aggravated battery. This is a really long statute. It is also divisible, and it is even divisible within the various subsections. We're not going to go over each of the 7 subsections under Illinois aggravated battery. We're going to go over a couple of them just in the interest of time. But it is divisible, and you have to look at each separate subsection separately in order to make your analysis of whether it is a CIMT, domestic violence crime, or a crime of or an aggravated felony crime. So let's look at 720 ILCS, at the aggravated battery ground under A, which is the offense based on injury. So take a moment to read the statutory language. You also have the sentencing information below, and then determine, is this a CIMT? Is this an aggravated felony? Is this a crime of domestic violence? And start going through the analysis of why it is a CIMT. Does it have that requisite mens rea? What is the level of injury? Is it an aggravated felony? Does it fall under that crime of violence definition? So let me go ahead and launch the poll while you all are reading this. And I believe it should be multiple choice, so you can check all or none, more than one, hint, hint. I'll give you guys like 15 more seconds because we're almost at like 50% participation. All right, so I'm going to end polling and show the results. Okay, so it looks like the majority of you thought that this was an aggravated felony, CIMT, and a crime of domestic violence. One of you said none, and then a couple of you said that it depends on the subsection. So let's take a look at the analysis in the next slide. So for those folks who said that it is a CIMT, you are correct. Look at the mens rea in the statute and look at the degree of harm that the statute requires. So a person commits aggravated battery when in committing a battery he or she knowingly. So knowingly denotes that higher level of mens rea. And then look at each of the subsections. So although it is even divisible within this subsection, all of them hold that you have to have great bodily injury or severe or permanent disability. So that level of injury is much higher than in difference to the general battery statute. And then for the crime of domestic violence, it could be a crime of domestic violence, depending on who the victim is, right? So we would need to find out who the victim of the battery was. And then for those who answer aggravated felony, yeah, it would be an aggravated felony. So if you look at the sentencing for this particular statute, the minimum for it is 1 year, if not more. So nicely done. So let's go to another one.
And Lupe, why don't we give our first CLE code right now?
That is right. I got really excited with the hypotheticals. You all, the first CLE code is categorical. Categorical is the first CLE code. All right, while you guys are writing that down, I'm going to go ahead and share the third hypothetical with you all. And this is for the subsection on aggravated battery based on an injury to a child or person with intellectual disability. So take a moment to read that. And then I'm going to go ahead and launch the poll for you all to fill out. We're almost at the halfway point. Give you guys like 10 more seconds. All right, I'm going to share the results with you all to see where we are at. So that's right. For those who answer that this is a CIMT, it has that level of mens rea and a high level of harm. It is also an aggravated felony because of the crime of violence definition. It has that high degree of physical injury and whatnot. And also it is a felony. So the minimum sentencing for this would be a year. And then depending on the victim, it could also be a crime of domestic violence. So let's go to what I believe will be our final aggravated battery statute. Okay, so take a moment to read this aggravated battery subsection based on the location of the conduct. And again, start thinking about it. Is this a CIMT? Is this an aggravated felony? Is this a crime of domestic violence? And I'm going to launch the poll. All right, we're almost at the halfway mark. This one's a little different from the other ones that we've traditionally seen. Think about the things that we've been discussing. What's the mens rea? What's the level of injury required? All right, I'll give you guys like 10 more seconds to cast your final votes. Okay, it looks like we are got a couple more people coming in, so I'll give you all a chance to respond. And all right. This one was trickier, especially in light of all of the other subsections that we've looked at. So you have to look at the prong of battery that it will refer back to, because it references based on a battery, but is it based on the first prong of battery, or is it based on the offensive provoking nature of the battery? And if it's based on the first prong involving bodily harm, then it would be a crime involving moral turpitude, and depending on the victim, a crime of domestic violence. If this aggravated battery is based on the battery that involves offensive touching, then again, it won't be either a CIMT, it won't be a crime of domestic violence, it won't be an aggravated felony, but it will still be a negative discretionary factor for folks. So that ends the aggravated battery portion of this presentation. I'm gonna send it over to Dave so that we can do more hypotheticals on Illinois statute. So.
Thanks, Lupe. And while we just transfer the controls over on Zoom, we got a question from the audience and just wanted to clarify something. For the aggravated felony offenses, we don't look at the possible sentences to determine whether it's a crime of violence, aggravated felony. We actually look at what the sentence imposed actually is. So I think Lupe talked about this, like with the battery statute, that's a class A misdemeanor. So it could never be a year or more of actual imprisonment imposed. So we know that that can never be an aggravated felony crime of violence. But when we get into the felony offenses, we don't look at like what type of felony it is to determine that, whether it's an aggravated felony. It's really just what sentence do they actually get. So just wanted to point that out.
Exactly. Thank you, Dave.
Okay. Okay, so let's keep going with the Illinois assault. Oops, sorry. May have already given you the answer to that. So let's take a look at the Illinois assault statute. So the definition for this is related to battery, but it's a little bit different. It involves an individual who knowingly engages in conduct which places another in reasonable apprehension of receiving a battery. So the sentence for this is a class C misdemeanor, which is 30 days or less. So let's do this as a hypo. The same questions as the past few hypos. Is this a CIMT? Is it an aggravated felony? Could this be a crime of domestic violence? Okay, great. Just a few more seconds, let you get your votes in. Okay, I'll end the polling and share results. Okay, great. So we have a spread of results here, which is fine. Like let's talk about this. This is a little bit different than the battery statute. So let's talk about this. So this is actually kind of more of a straightforward statute than it may actually seem. There's actually a few cases that's saying simple assault is not going to be sufficient to constitute a CIMT. And we have actually a Seventh Circuit case saying that there's this near universal agreement that it won't rise to the level to be this a CIMT. And again, that sort of goes back to that chart about the level of harm and the level of mens rea. When we're putting someone in a reasonable apprehension, it's not the same kind of high level of harm that you'd see in a battery statute, for example. It's also not likely to be a crime of domestic violence. But just take a look that the physical harm subsection of battery could potentially trigger this. Just because the reasonable apprehension of bodily harm, that goes to this sort of like use or threatened use of physical force, which is that definition of the crime of violence, which we apply to the domestic violence setting. So just be careful on that. Like if it's sort of clear that that could be at stake, that could potentially trigger the DV ground of removability. But we know it's not an aggravated felony because, again, because of these levels of harm issues, but also because of the sentence. It's a class C misdemeanor. So there's no way that someone could actually be sentenced to a term of imprisonment of a year or more. So like battery, there are also different versions of the aggravated assault offense in Illinois. And so it's just like battery, it's assault, but with aggravating factors. And those factors are different based on the location of where the assault occurs, based on the status of the victim, and then also based on the use of a firearm, a device, or a motor vehicle. And the sentences range in aggravated assault between Class A misdemeanors to Class 3 felonies. So before we go into some hypotheticals on this, I just want to mention this case, the VC case from 2020 from the Seventh Circuit. So the Seventh Circuit has held that the aggravated assault crime under Illinois law is a crime of violence. And the way that they reasoned this is somewhat unique. They said that the assault definition is based on placing another person in reasonable apprehension of receiving a battery, which we know, and that there are these two types of battery, which we've talked about. One is this bodily harm type of battery, and the other is the offensive touching battery. So what the Seventh Circuit said was you really have to go in and see what kind of battery we're talking about here when we have an aggravated assault conviction. And they reason that that's because battery is divisible as to this bodily harm and offensive touching, these two subsections. They said because of that, the aggravated assault statute is as well because it's referring to this battery statute. And so practically what that means is courts can look at the record of conviction when there's a conviction for aggravated assault to determine whether the actual conviction is based on this reasonable apprehension of bodily harm or of that offensive touching. And so this is actually somewhat of a troubling case because it allows this reach into the record of conviction to figure out what was actually going on. And it's our interpretation that this is a very loose application of the categorical approach, where really, like we talked about at the beginning, we're just supposed to be looking at the statute at issue and the statutory language. But they're basically, the Seventh Circuit is saying you can go into the record of conviction to figure this out, like at this stage. And so, if you have an aggravated assault statute, you should, this case is on point, but it should be challenged as not really being consistent with, our understanding of the categorical approach and the modified categorical approach. So let's move actually onto the domestic violence grounds. As we talked about, these DV offenses, the state domestic violence offenses can be a lot of different immigration offenses. Sometimes they're CIMTs, sometimes they are the crime of domestic violence as defined in the INA, and sometimes they're aggravated felonies. To be a CIMT, it must involve the knowing or perhaps the reckless infliction of bodily harm. And like we talked about for the CIMT standards, for a crime of domestic violence, it has to involve this use or threatened use of violent force against a domestic partner. And like we spoke about earlier, there's a special approach called this circumstance-specific approach to figure out the nature of the relationship between the offender and the victim. So it doesn't just have to, what that means is it doesn't have to be titled a crime of domestic violence in, like, under Illinois law, for example. It could be like a battery offense that it's clear from the sort of the record of conviction that it was battery of one of these protected victims in order to be this sort of domestic partner, this domestic violence offense. But definitely when you have an offense that's entitled a crime of domestic violence, that also raises the specter as well of being a crime of domestic violence. And then these DV offenses can also be a crime of violence aggravated felony, again, if it has this use or threatened use of violent force and the actual sentence imposed is a year or more in jail. So let's take a look at the Illinois domestic battery offense. This is, it's very similar to the battery, the general battery offense, but there's some key differences. So we have domestic battery if an individual intentionally or knowingly causes without legal justification by any means bodily harm or this physical contact of an insulting nature. And let's launch the poll for this. It's the same questions as before. CIMT, aggravated felony, or crime of domestic violence. And again, we have the sentences range from Class A misdemeanor to Class 2 felony. Okay, just a few more seconds. I know these polls are hard because you have to do a couple of different analyses. So great job. I'm going to end the polling. Great, and there's a wide variety of answers here, and so let's take a look. So this one, we're also going to want to break it down by the subsection, just like the general battery offense, because actually, and we didn't tell you this, but just like the general battery offense, this is also going to be deemed a divisible offense. So you can look at the different subsections and treat them as different crimes, basically. So subsection A1, that's that bodily harm subsection, right? And so like the general battery offense, it's probably going to be a CIMT, and it's probably going to be a crime of domestic violence, because we have that that element of the victim is one of those victims is classified as a domestic violence victim. And the important thing is it doesn't matter the sentence for the crime of domestic violence or the CIMT. But also subsection A1, it will probably be considered an aggravated felony if there is that sentence of a year or more imprisonment. But then when we look at subsection A2, that's the offensive touching subsection. So even though this is more narrow than the general battery statute in that we're talking about offensive touching of a protected family member, it's still probably not going to rise to the level of these types of offenses. That being said, it could be a negative discretionary factor in applications for relief or other situations, such as like a bond hearing. So that's definitely something to keep in mind. And again, the subsection A2, this offensive touching, the level of harm just isn't high enough to really meet that level for these types of offenses. And just like the other battery offense, there's also aggravated domestic battery under Illinois law. And so I'll let you read the different subsections here, but in committing this domestic battery, it's limited to individuals who knowingly cause great bodily harm or permanent disability or disfigurement. Also, individuals who strangle other individuals will be committing aggravated domestic battery. And then there's a very specific definition for strangle under Illinois law. Instead of doing a hypothetical, I think it's hopefully clear at this point from our other examples that the level of harm here is high. And there's no offensive touching subsection alternative here. So this is definitely a CIMT, a crime of domestic violence, based on that. And also the aggravated felony issue could come into play again if that sentence is a year or more imprisonment. Sorry. Okay, now let's move on to order of protection violations. This is actually just below the crimes of domestic violence in the INA. It's subsection 2 under subsection A2E2 of section 237. And like Lupe said earlier, the issuance of an order of protection will not make an individual removable under this ground, but it's someone who the court has determined violates this order of protection. And it has to be specifically the portion of a protection order that involves protection against credible threats of violence, repeated harassment, or bodily injury to the protected person. And also, like Lupe said earlier, the board has held that a violation of a no contact provision qualifies as one of these offenses. Because even though it may not be expressly in the language of this no contact order, it's implied that the purpose of no contact provisions is to prevent these future threats of harm and harassment and injury. So the Seventh Circuit has a case, Garcia Hernandez from 2017, in which it says the categorical approach, which we talked about at the outset here, does not apply to these types of violations, the order of protection violations. And that's pretty important for our analysis in any type of order of protection violation case. And the reasoning behind that is, the Seventh Circuit said, this sort of violation does not depend on a criminal conviction like other categorical approach grounds do. But instead, it depends on what a court determines about the non-citizen's conduct. And I'm just going to go back quickly. The language of the INA here, it's talking about whom a court determines has engaged in conduct. So that was enough of a hook for the Seventh Circuit to say, we're not talking about an actual conviction, we're talking about this determination of a court. And so if there's no conviction, we're not bound by this categorical, this sort of strict approach of using the categorical test to determine this conduct. So instead, what the Seventh Circuit said was, what matters is what the state court determined about the individual's violation of the protection order, which we can take from the record of conviction. So in looking at the Illinois statute that's important here, the violation of an order of protection, it's a pretty broad statute. You can violate an order of protection by a lot of different conduct, including prohibition of abuse, neglect, or exploitation, the grant of exclusive possession of residence, a stay-away order, prohibition of entry, prohibition of a firearm possession. So this is pretty broad, but again, because the categorical approach does not apply to these sorts of offenses, it's pretty likely that the order of protection violation under Illinois law is going to match the standard for under the INA, unless you have some sort of facts from the record of conviction that don't point to something that is dealing with like threats of violence or this like a no contact order. But it's likely that it's going to be a problematic for your client. Okay, so key takeaways here. This is our last slide before we open this up to questions. And actually, before I do this, let me give one more code. Our final CLE code is aggravated. Aggravated is our final CLE code. So take a minute to jot that down for CLE purposes, aggravated. Okay, so our key takeaways here, make sure to look at the state offense to see if there are any overbreadth arguments under the categorical approach. Again, meaning whether the state offense you can be convicted under that offense for conduct that's not going to have any immigration consequences, basically. When a statute is divisible under the categorical approach, or if the categorical approach does not apply, try to have your client plea, if you're working with your client in the criminal context, try to have your client plea to that overbroad subsection when possible. Because that, again, if you could make some sort of plea deal with the state's attorney, that is going to benefit your client down the line. If it doesn't really matter to the prosecution on which subsection your client pleads to, that can go a long way for your client. That's not always possible, but sometimes it is. And then finally, just look at state and federal case law for divisibility arguments. There are always creative arguments that can be made, especially when there is no state or federal, or when there's no federal case law on whether a statute is divisible. Most of the offenses that we talked about today are divisible or aren't, or they aren't actually subject to the categorical approach. But so make sure you know sort of like what the federal case law is for each statute that you're looking at, as well as state case law for any sort of overbreadth arguments. Also, like we talked about before, things have changed in the categorical approach over the years. So make sure you're looking at more recent federal case law in terms of the understanding of the categorical approach. A lot of cases from the Seventh Circuit, for example, from like 2002 or 2007, may not have the most recent understanding of the categorical approach under Mathis. that we really look to, which is a more recent case. It's from 2016. Sometimes they are, I mean, sometimes they do follow basically the same approach and they're binding and persuasive authority, but sometimes you want to look at sort of what the context is for those cases. And also even in the more recent cases, like we talked about that United States versus Vesey in the aggravated assault context, that's a recent case from last year, but see if there are creative arguments around those kinds of holdings. So thank you very much for participating today. We enjoyed being here. And let's open this up to questions. Let's take a look if any questions came in. Feel free to put them in the chat. I think it might be the best way to.
There's two already relating to OPs, Dave. The first one is can the court determining the violation be the court that issued the OP, or does it have to be a finding in criminal court?
Yeah, I mean, I think it has to be.
I think it's a definition of what a conviction is, right?
Yes, it goes to conviction. That's right. It has to be a conviction for immigration purposes. So there has to be some sort of finding of guilt, and also some sort of punishment involved. So I think it could be in either context, depending on those.
Mm-hmm. And then the other OP related question that we have is, what if the person in removal proceedings committed the violation of an OP offense in a different circuit? So what if, I guess, the person was convicted of a OP violation and they were in removal proceedings in another circuit court?
Yeah, that's a great question. I mean, so if the person is in removal proceedings in Chicago, or wherever they are, that's the circuit law of that immigration court will control. So like, for example, if someone has a violation of an order of protection in Minnesota, that is in Minnesota, they're under the 8th Circuit. But if the person's in removal proceedings in the 7th Circuit, then we look at that 7th Circuit case from 2017 that controls that. So yeah, so it actually doesn't matter what state. It could be a Texas statute. It could be a California statute. If the person's here in Chicago, we just look at the 7th Circuit law for that. I mean, you could look at, I mean, if there's an analysis in that circuit in the state of order of protection violations for immigration purposes, I think it's great. It's persuasive authority. You should look at that and cite to that if it helps you, but ultimately it's going to be bound by the 7th Circuit.
And it looks like we have another question. For the circumstance-specific approach, the court can reach past the record of conviction, yes. For example, in determining whether the victim is a protected class, can they look at the record of conviction, and can they also look at the police report?
Yes, I think they can. I think the circumstance, I mean, it probably should be bound to the record of conviction, but I think it might be difficult if the police reports also mention the protected victim. I think judges are probably going to find that that's sufficient.
I think so too.
Yeah.
And then looks like we had comment. I had DHS argue that any violation of OP, even if not a domestic relationship, is removable under this statute. I believe this is wrong because of the definition of protection order must be to protect DV. Do you agree?
Yeah, let's just look at the. Yeah, I mean, when you look at the action, I mean, it's definitely an interesting argument, but it doesn't necessarily say it needs to be like a family member, sort of like the domestic violence ground. It just says whoever was the person who for whom this order of protection was issued against. So it could be anyone. I think is the way I'm reading this. Is that?
I think so too. I mean, I think it's an interesting argument to raise and see what other courts have done, but it doesn't have that for the purposes of this clause, so the statute excerpt means the term protection order means any injunction issued for the purpose of preventing violence or threatening acts of domestic violence. And you're also finding that in the INA, or where's the statute excerpt coming from?
Yeah, I mean, it is saying acts of domestic violence. It's interesting question. I would argue it. I would say it can't be an act of domestic violence.
Section E2.
Yeah. Preventing violent or threatening acts of domestic violence. Yeah, I actually, we didn't include that part. The statute does go on. So I would argue that it's an act of domestic violence would have to have that protected relationship. And so if there is no protected relation, yeah, it's an interesting argument.
Any other questions that folks may have? Or other argument ideas for things that we can.
Yeah. Okay, well, we can, please feel free, if you have other follow-up questions later, feel free to reach out to us. Yeah, thank you for coming. We'll send out information on collecting CLE credit after this. Like Lupe mentioned, we have another training in a month. It's April 16th on particularly serious crimes and their effects. Also these criminal effects on other forms of relief like asylum and withholding of removal. So thank you all very much. And we'll see you next time.
All right, thank you, everyone. I think we got all of the questions.